Hi, I'm Aidman, and in today's video, I'm going to discuss bad faith claims against insurance companies. Sometimes insurance companies do bad things when they're investigating and processing claims, and sometimes they do really bad things. If you're in the really bad things category, you should be considering making a bad faith claim against the insurance company. The area where this becomes most relevant is where there is a very substantial injury claim and limited coverage. So, for example, if the plaintiff has suffered significant injuries, say the case is worth $100,000, which is a major injury, and the defendant, the person who caused the injury, only has, say, $15,000 worth of coverage, you would think that the insurance company would pay that $15,000 pretty early in the process. Usually they do. Almost always they do if your lawyer knows what he or she is doing. But in the circumstance where the insurance company is just being completely unreasonable, the lawyer should send what's called a bad faith letter. And that letter will set forth that the plaintiff is willing to settle the case for the policy limits of $15,000 and give a full release to the insured, which protects the insured. It protects the person who has the $15,000 in coverage. It protects their personal assets. And the letter should say, this offer to settle will remain open for, say, 30 days, after which the offer will be withdrawn and will not be reopened, and things will proceed. And if there is a judgment in excess of the $15,000, that they will seek to collect the judgment against the personal assets of the defendant, the person who only has the $15,000 in coverage. That will get the insurance company's attention. No insurance company employee wants to be accused of bad faith, because by exposing their insured's assets to an excess judgment, ultimately the money's not going to come from the person. It's going to come from the insurance company itself. So if I collect a $100,000 jury verdict and they could have paid $15,000 and be done with it, they've exposed their insured to an $85,000 worth of personal assets exposure. And by doing that, they've created a bad faith situation, and the court may well reform the insurance policy to make it a $100,000 policy. The insurance company itself would have to pay the full $100,000 if the court found that they indeed acted in bad faith, and that gets the insurance company claims representative who mishandled the case in big trouble. And that's why bad faith letters are extremely powerful and why they lead cases towards settlement in a hurry. If you'd like to discuss this, or you'd like to read more about bad faith cases, get my book, Winning Personal Injury Cases, and I'll be happy to send you a free copy.